I'm particularly interested in what you have to say about Hobby Lobby, so.
Well, I want to
I
keep
know,
going,
so
yeah.
can we go to those?
So I think they're going to overrule it. And part of my question then, and actually something I'm in the process of writing about right now, is, well, so what happens next? Because I don't think the anti-gay rights movement is going to just lay down and die. I don't think that they're going to go away. And in fact, they're really gearing up sort of behind the scenes for what they see as sort of the next sort of fallback battlefront. And I think it's discrimination, and we got the first hint of it. I don't know how many of you saw in the newspaper a couple days after the Ninth Circuit that the Hitching Post up in Coeur d'Alene filed a lawsuit against the city of Coeur d'Alene. This lawsuit is the craziest damn thing I have ever seen. Because I've now talked to the Coeur d'Alene city attorney, and we know that what happened in the case is a couple months before the Ninth Circuit, the Hitching Post was incorporated as a secular marriage statute. With no corporate purpose, no relationship with the church, and no corporate purpose. And in fact, their corporate purpose indicated that they did both religious and civil marriages. And about 2 months before the Ninth Circuit case came down, they call up the city of Coeur d'Alene attorney and inquire how they might be affected by the Ninth Circuit. And the city of Coeur d'Alene attorney visits with them, spends some time, and tells them, you know, I think, because Coeur d'Alene has an anti-discrimination ordinance. I guess that's the other piece I should have added. He says, well, I think you're going to have to do same-sex marriages if the Ninth Circuit decides this way. I mean, you guys aren't a church. There's a religious exception, but you're not a church. Well, so then the Hitching Post does the most bizarre thing, because I think they want to be part of this litigation. They amend the corporation charter to make it be exclusively for religious purposes. And then the city of Coeur d'Alene is just ignoring them. They don't even care that they're out there. They don't do anything. They never call them up 2 days after the election, having not talked to them for 2 months since the first phone call. They sued the city, saying, you can't enforce the Anti-Discrimination Act against them. And the city attorney's going, I hadn't thought about it, not high on my priority list. A and B, they attach their new corporate charter, and the city attorney says, well, we have a religious exception, and so now that you've changed your corporation charter, we don't even think you're covered by these provisions in our code. Some not very smart lawyer who wanted to plan this litigation did a really bad job about it. I don't know what the status is, but I do know that the city was going in and saying, we agree with them, so let's dismiss. And I don't know what's going on right now.
So, I'm sorry, what does that mean? That
Well, the next big front is this religious discrimination argument. A lot of conservative churches and conservative groups are saying, okay, well, if you're going to recognize gay marriage, you can't make us either perform such marriages or recognize or support such marriages, okay? And I think the Hitching Post case is just our own little, very stupidly formulated attempt to jump on that discrimination bandwagon. But it's gotten all kinds of national attention. You Google it, you'll find articles about it in the Heritage Foundation and all these conservative marriage groups. They're all behind some conservative political action group is representing the Hitching Post, and I don't know what the heck's going to happen in the case. But there have been a bunch of these cases. Now, these discrimination cases, they are an issue regardless of whether states recognize gay marriage or not. The question is whether religiously oriented groups and people can obtain an exemption from the enforcement of anti-discrimination statutes so that they can discriminate against gays and lesbians. And of course that doesn't matter whether they're married or not, they still just want to discriminate. And so, but the marriage issue has somehow just really triggered this visceral response. So there's all these cases. There's a couple florist cases where they didn't want to provide flowers for a gay wedding. There's the wedding cake cases, and then there's a bunch of states that are considering legislation that expressly exempts religious religious organizations and groups from discrimination on the basis of gays and lesbians. Yeah,
Liz, do religious organizations have an exemption with regard to race?
no.
If anybody's interested in that
Well, it's the
Colorado
same
case,
thing,
I
isn't
think
it?
they had a piece on it
I
on the PBS
Yeah.
NewsHour last Wednesday night.
Yeah, it's been in the news recently. The thing is, there's big ammunition for this argument. And that ammunition is the Hobby Lobby case. So many of you might have heard of this case. It was decided earlier in 2014. It's not a gay rights case. It was an abortion rights case. Hobby Lobby wanted, under Obamacare, Hobby Lobby was going to be required to provide, to cover contraceptives in its health care insurance policy for its female employees. And Hobby Lobby did not want to do that, and they said that providing those contraceptives violated Hobby Lobby, the entity's religious beliefs. One wonders how that happens, but I don't know. They go up to the US Supreme Court, and in an opinion that's just bizarre, written by Justice Roberts says, right, Hobby Lobby does not have to cover contraceptives if it violates their religious beliefs. They get an exemption. So that's out there, and it is displacing prior approaches to this issue. So under the Hobby Lobby decision, if the law imposes a substantial burden on religious exercise, which, just to put that in perspective, the court says paying pennies more on your health insurance policy to provide for contraceptives for women employees imposes a substantial burden on religious exercise of a corporation, and the burden doesn't serve a compelling state interest, which this is code word for there's no such thing. When you see that language in the Supreme Court, there are no compelling state interests. They've never found a compelling state interest, except in one case, in the Japanese internment case, the Korematsu case, the court found that there was a compelling state interest to intern Japanese citizens of the U.S. And along with the Roger Taney's opinion in the slavery case, they are the two naviers of American jurisprudence. Nobody will own those cases. They're horrible, and they just reflect bald racism. And so compelling state interest, code word for there is no interest that's that important. And it's the least restrictive means of obtaining a result. Which the court says, well, there's less restrictive means for women to get contraceptives than covering it in your insurance policy. One wonders how.
They don't have to tell you that.
So what are their hiring practices?
I have no idea, but if you know anybody who wants to work for Hobby Lobby, I guess I would say think again.
But I mean, isn't it illegal to not allow, to discriminate in hiring practices?
Sure, they can hire women, they just don't have to provide them with the health care that they need. They're not refusing to hire women.
Yeah. It just seems kind of connected. It seems like there's
Oh.
some way to get them.
In my world and in your world, this is all part of a policy that says women shouldn't be in the paid labor force, they should be at home, they should be having babies, and they should be carrying out that role. But that's women's role.
Isn't this a disguised attack on the Affordable Care Act?
Well, that's the other thing, and it's a bad case, it makes really bad law. I actually don't think that's what the court thought it was doing, but the conservatives on the court so much want to attack the Affordable Care Act in any way that they can, that I agree, that's what drove this case. It's an anti-Obama decision, an anti-Affordable Care Act decision, but it's precedent for discrimination. And it's given the whole religious discrimination in the gay rights arena just real legs. So I think that, a religious organization that wants to, you know, if you say my florist shop is religious and we don't want to provide flowers for a gay wedding, my wedding chapel is religious and we don't want to do, even if it's not incorporated as a church and we don't want to do these weddings, you know, my whatever, my banquet hall is religious and you can't have your reception here. It remains to be seen, but I think Hobby Lobby's the roadmap for that being okay. So I do think there's a really big fight to be fought here. I hope it results in Hobby Lobby going away and being one of those temporal decisions that just was ill-conceived and it gets narrowed down and overruled. But I think that's the next fight.
Remember how long it took us for Plessy versus Ferguson?
Yeah. So, but I do think that that's the next fight, is the religious discrimination fight. Also, in the meantime, I think that there's some really interesting things to think about, and this is really relevant on also the question of what happens if the Sixth Circuit affirms, if the U.S. Supreme Court affirms the Sixth Circuit. So remember that Section 2 of DOMA, saying states don't have to respect other states, is still in force. And we still have 13 or 14 states, and probably more, depending upon what the Supremes do, that don't recognize same-sex marriage. And so the problem's a train wreck. Because it means that you're going to divorce. So you get married in Massachusetts, a state that has legislatively recognized same-sex marriage and obviously will be unaffected by anything the U.S. Supreme Court says in the currently pending cases. You get married in Massachusetts, but you get a new great job with Micron down in Boise, and you move here, and the stress of the relationship, of living in an unsupportive community, whatever, the relationship breaks down. Can you get divorced in Idaho?
Probably not.
Well, actually, then let's put it in let's have you move to Mississippi, where we have no pro-gay marriage law, or Georgia. Can you get divorced there? The answer is really an up-in-the-air question, and it is probably not. But if you're a family law geek, you also understand that going back to, after you've been in, let's put them in Georgia, not Idaho. You've been in Georgia for a couple years by the time the marriage breaks down, and you want to go back to Boston where you were to get the divorce, there's probably no jurisdiction in Boston. You probably can't file a case there because you're not a resident of Boston. So how do you get divorced? Somebody's going to have to move to a state that will do the divorce, is what's going to happen in those cases, and that's craziness.
What is the residency requirement in Nevada now? It's
I don't
30
know.
days in Idaho.
6 weeks, six weeks in Idaho. It's nothing in Washington.
Yeah.
I don't know what it is in Nevada. Paternity and maternity. So I always like to say to my students when I talk about this in heterosexual relationships that, you know, our law just always assumes that we know who mom is and we just never know who dad is. That dads can sprinkle those little sperms all over the place and we just never know who dad is. So how do we know who dad is most of the time? Because he's married to mom.
Oh.
Really?
No.
Every single state has somewhere in their books a statute that says that the man who's married to the mom at the time the child is born is presumed to be the dad.
Yep.
Without that statute, we know who mom is, but we don't know who dad is.
And then you have sperm donors.
Well, but if mom's married and there's a sperm donor and that baby's born during the marriage, mom's husband is the presumed father, not the sperm donor. Okay? Well, so when people are married, take our Massachusetts couple again, and let's assume that they decide to have a child. Now, if they were in a non-marriage state, that child could be biologically related to one of them, but can't be biologically related to the other. And so there would need to be an adoption in a non-marriage state in order for the non-biologically related parent to obtain parental rights. But in a marriage state where you're married to the biological parent, the presumption about marriage has just been expanded. So that bio mom in Massachusetts, her spouse is presumed to be the co-mom of the child. born during their marriage. You don't have to do an adoption or sign any other papers. We just have a kid with two moms who were married to each other when the child was born. Right? Well, when they moved to Georgia, we have no adoption order. Is non-bio mom? If Georgia will do our divorce, can non-bio mom get custody? Who knows? But that leaves the parentage of that innocent kid just sort of up in the air if you're moving around. Even if they wanted to try and deal with it, if they went into court and non-bio mom filed an adoption petition in Massachusetts just to be on the safe side in case they went to a non-marriage state, I'm fairly certain that the Massachusetts court would dismiss that adoption petition saying, you can't adopt your own kid. You are already the parent of that kid. We can't give you an adoption order. You have better rights than adoption, sort of. You're the presumed parent. Only a non-parent can adopt. Inheritance. So the marriage doesn't break down. They move to Georgia and they've got Junior along with them and nobody's questioning the parentage, but non-bio parent dies in a car accident. Can bio parent and kid inherit? Make our non-bio parent the breadwinner in the family, the primary income. Bio parent's a stay-at-home mom. No will. And that one you can fix with a will.